All right, this is case number 25CR43256, the State of Ohio versus Jeffrey McDaniel. We are here today for a final probation violation hearing. On Tuesday, May the 5th, Mr. McDaniel was present for a preliminary probation violation. He said that he understood the allegations and waived his right to counsel. Are we ready to proceed?
Yes, Your Honor.
Ms. Tranter, call your first witness.
State will call Hannah Martinez.
I read his conditions word for word as listed in the document. I answered any additional questions he may have had.
Okay. And on page 2 of that document, there's a couple signatures, right?
Yes, ma'am.
And what are those signatures?
The first signature is from Jeffrey McDaniels. The second signature is mine.
Okay. And he personally signed that in front of you?
Yes, ma'am.
Acknowledging that he understood the rules?
Yes, ma'am.
Okay. And the date on that document actually on the second page is April 28th?
Yes.
Okay. So that's the date that this was actually executed. Is that correct?
Yes, he was released from custody of the Warren County Jail on that date.
Okay. And when after he signed the rules of probation with you, what was the plan for him? Where was he to go?
He was ordered to go and engage in heel space in Toledo.
Okay. And do you know how he was transported to Heel Space?
Heel Space had an Uber come to Warren County Adult Services where they picked him up and transported him to their agency.
Okay. And part of his community control, I believe he was on electronic monitoring as well?
Yes, ma'am.
Okay. So did you ensure that he got in the Uber and was on his way to Heel Space?
Yes, ma'am.
Okay. A short time later, did you receive information that something was going wrong with Mr. McDaniels regarding his probation?
Yes, ma'am.
Okay. Tell us, how did you become aware that there was an issue?
I had received notification from electronic monitoring that the defendant's sister had contacted us to notify us that he made threats of removing his ankle monitor. At that time, I had contacted Heel Space to touch base with them to determine what was going on and if Jeffrey McDaniels had made it there safely. They had indicated that
Let me ask you this. This contact, was it via phone, via email?
it was via phone where I had a communication with them. After completing that conversation over the phone, I'd asked that they sent me documentation of that conversation.
Okay. So what was your conversation with them on the phone?
So based on the email in which they provided me, they stated that upon arrival, he became upset, he being Jeffrey McDaniels, about learning that his personal property from a previous stay had been donated. As outlined in their policy, any previous property left behind for more than 7 days is subject to donation or disposal. Following this, Jeffrey became increasingly agitated and began making threats of physical harm towards both residents and staff. Due to the severity of this behavior, housing staff did not feel it was safe or appropriate to proceed with the intake process. Law enforcement was contacted to ensure the safety of everyone involved. Upon their arrival, Jeffrey was taken into custody due to the active warrant in which I had issued. Now, I did confirm with them that, just for clarification, that Jeffrey McDaniels is not permitted to return to Heel Space due to this behavior. They did say that was correct and that he was added to their red flag list.
Okay. And that conversation you said was documented in an email, correct?
Yes, ma'am.
All right. And I'm going to hand you what we're marking as State's Exhibit number 2 for purposes of that hearing. Can you identify that document or those documents that are contained in there?
Yes, ma'am. This would be the email communication that I had with treatment.
Okay. And part of the rules that Mr. McDaniel signed in State's Exhibit number 1, special condition number 15B is what?
Special conditions 15D states no contact with Sherry Spencer.
No, I'm sorry. I said B as in boy. That
Oh,
was, yeah,
excuse me.
that's okay. 15B.
Special condition 15B would be to undergo and successfully complete a program of alcohol and drug treatment as directed by the probation officer.
Okay, and that was to be the Heal Space program, correct?
Yes, ma'am.
All right, and their indication to you was that he was not going to be able to complete because he wasn't going to be able to enter, correct?
Yes, ma'am.
All right. Now let's talk about special condition. Let's go to special condition 15D, like dog, and that one is the no contact with Sherry Spencer, correct?
Yes, ma'am.
And did you receive information that Mr. McDaniel did in fact have contact with Sherry Spencer?
Yes, ma'am.
How did you come to know that information?
I had been notified that he had made contact with Sherry Spencer through the victim's advocate.
Okay, and what did you do with that information?
Based on that information, I had asked that victim's advocate send me documentation that he had made contact with Sherry Spencer. Once I received that documentation is when I issued the warrant.
Okay, and I'm going to hand you simultaneously here what we've marked as State's Exhibit 3 and State's Exhibit 4. So let's talk about number 3 first. Can you tell us what that series of documents is?
In Exhibit 3, this is a Cash App request that Sherry Spencer had received from Jeffrey McDaniels for $424 to pay off loan balance.
Okay, and how are we identifying that Sherry was indeed the recipient of that contact?
It is coming from Sherry Spencer's email address. This is coming from the Cash App account that she has.
Okay, and is that indicated in the address there, 2 SL Roy 2?
Yes, ma'am.
That's Sherry's email address?
Yes, ma'am.
Okay, and the second page of that document, that displays who sent that request, correct?
Yes, ma'am.
And who sent that request?
Jeffrey McDaniel.
Okay, and on the third page of that document, what is that? There's some pictures and looks like some profile pictures.
Yes, so that is a screenshot of her phone directly in which Jeffrey McDaniels had requested the $424 to pay off his loan. It also has a picture of Jeffrey McDaniels.
Okay, and is there a date on this request that Sherry received it?
So the date that I have would be the date of the email, which would be April 28th, 2026.
Okay, at approximately 3:00 p.m.?
Yes.
Looks like that's Central Time.
Yes.
Okay. Do you know what time you met with Mr. McDaniel to sign his rules?
It would have been earlier that morning.
Okay, so prior to the 3:00.
Yes, ma'am.
All right, and if you look at State's Exhibit number 4, tell us what that series of documents.
Exhibit 4 is email communication in which Sherry Spencer had sent Erica, our victim's advocate, documentation of a text message that she had received from what she believed was Jeffrey McDaniel.
Okay, and what did that text message contain? Another Cash App request?
So, yes, Exhibit 4 has a Venmo request in which he had requested $300. It also includes text messages that were sent from what she believed was Jeffrey McDaniel.
Okay, and why did she believe that this was Jeffrey McDaniel?
In the text message, it states that this is JR with supporter. She had communicated with me that he is a junior and that they had made an agreement prior to his trouble here that she would make financial payments to him if he stayed out of trouble. Due to him being incarcerated, she had not paid him, and so he was requesting those payments. She says he would have gone by JR with supporter.
Okay. All right, and again, the date of that email is what, date and time?
April 28th, 2026 at 3:19 p.m. Central.
Okay, so approximately 20 minutes after the time that exhibit number 3 was sent, correct?
Yes, ma'am.
Okay. So when you received those documents and that information from Sherry, did you consider that to be a violation of special condition 15D, like dog?
Yes, ma'am.
Okay. All right, Ms. Martinez, I have no further questions for you. Thank you.
Mr. McDaniel, do you have any questions for Officer Martinez?
Yes.
Yes.
When I spoke to you in the office, did I aware you that my sister would more than likely try to sabotage my recovery in some form or another, that you should not speak to her at all prior to our, what you spoke to her before? I gave you no permission to speak to her on my behalf. Is that correct?
That is not correct. What we discussed,
Remember, you're under oath.
Sir, let her answer, hang on.
what we discussed was that a release of information would need to be completed for me to give your sister any additional information about your case.
So how did she have your phone number?
She did not have my phone number.
Okay. Well, she talked to you personally.
No, she did not.
Okay. And are you aware of the timeline of me going from your office to Hill Space?
Only what was provided to me by Heal Space.
Okay, so am I allowed to tell her the time frame?
Ask her a question.
Okay. So you were aware that I was there, I got there at 1:47 p.m.?
I do not recall that exact time, but I do know that you arrived in the afternoon.
Okay, are you aware that they drove me from 5085 Monroe Street to 501 North Detroit in their van, which I arrived 20 minutes later?
No, sir.
Okay. And do you have any proof besides them just saying that I became irate or that I yelled or screamed or anything like that? Or they just emailed you that and said that?
Law enforcement was called. I do have documentation of a report number that was provided to probation.
Are you aware that I told them to call police because I was court ordered to Hill Space and they were trying to kick me out because they donated all my stuff, and saying that the victim was the one that called and said I was not getting out anytime soon to donate all my property? Are you aware that I was the one that told them to call the police because I did not want to violate probation in that regard?
No, sir.
Okay. That's no further questions, Your Honor.
Any redirect?
No, sir.
Officer, you may step down, thank you. Would you hand me those exhibits? Thank you. Anything else, Ms. Tranter?
No, sir.
Mr. McDaniel, do you have any witnesses?
No, but I have some documentation that I would like to present to the court.
Hang on.
I believe you guys have.
He's got, said you have some documents you want me to see?
Yeah. I guess we could just go. This is a ex parte request, a TPO request, and if you'll look on, you can take them all that, but on the page right there, you'll see a statement from Sherry Spencer.
This is all one document, correct?
Yeah, but
Okay.
I just really
You want
wanted
you want me to see this part?
Yes,
Yeah.
the whole statement, Your Honor.
Okay, so what he's handed me, it looks like it's a petition for a protection order from the District Court of Cleveland County in the state of Oklahoma, correct?
Correct.
And this is all one document, but it's been separated because you want me to see this handwritten portion,
Right.
correct? Okay, I'm gonna take a second and read it.
Okay.
What I was doing there, when I paused, I was trying to see when this was actually filed in comparison to the date of your sentencing.
I believe it was the same day on the 28th, Your Honor.
Well, you were sentenced on the 27th.
Yeah, but I didn't leave until the 28th.
Right,
of
okay,
jail.
yeah, you were released from jail on the 28th.
Correct.
But you were sentenced on the 27th. This is dated the same day as your release.
Right.
Okay, all right, what else do you want me to know?
Your Honor, with that being said, if you recall, the plea agreement we had, it was mostly based on, trying to rekindle the relationship with my mother. She wanted me to seek treatment, which I agreed to, and, upon my release, she's, now wanting a 10-year TPO, which is a lot more than a no contact order because that's criminal. This is just, you know what I mean?
I do.
So, and also if you read that statement, what you have, and you go back to our statements that we had of the case, totally different statements. That would tell you right there that Allison Coulter, your witness, lied because Sherry's telling you that she lied, along with Sherry.
Whoa, who's Allison, who?
Coulter. That's the witness of this case that made this case criminal. Sherry says that her niece, that's her niece was witness to the whole thing. her niece is the one that said I had a knife and all types of stuff, and I did a bunch of stuff that I didn't do. And you recall I said that in court. So I just want the court to understand that this whole thing is being blown way out of proportion. And now my mom is wanting a 10-year TPO, which I absolutely don't have a problem with. I just have a problem with her being the one who called Hill Space upon.
I thought your sister called Hill Space.
My mom called Hill Space upon me coming to jail and told them that I was not getting out of jail anytime soon to donate all my property.
Okay.
I used the peer support.
But you knew, hang on a second, that fact that your property was gone, you knew before you even left here.
No, my sister said on a recorded line that it was secure and it was in storage until I got out.
But I thought you were angry.
But I called, but I used peer support.
Let me ask you a question, okay, and I'll let you respond.
Go ahead.
When you were before me the last time at sentencing, you were angry that your family did not go up and pick up your personal belongings.
Correct.
So you knew they hadn't got you, that they didn't get it.
Right, but they were lying to me, Your Honor. They were saying that it was secure, and then when I called them myself through the peer support in the jail, they said they destroyed it. They didn't say they donated, and I said okay. And then I called my sister that same day, and she picked up, and she said no. They assured me it was safe. So I went back to Hill Space on my request, and you allowed me to. And all I asked them was, I said, are you saying that the victim called you guys who had no ROI, had no emergency contact, called you and said to give my stuff away? And they said yes. I said, so how do you guys want to proceed on fixing this? And they in 2 minutes after I said that, they said there's a problem with housing. You need to leave. I said my judge sent me here. I can't leave. They said, so you want me to call the police? I said yes, call the police. I sat down and I waited till the police came. I never got irate. I never raised my voice. The only thing I spoke to the man named Rico, he's the gentleman that was there. I said, what would be acceptable in this situation is you take me to Walmart and get me my essentials, and you help me get donated clothes that you did before. They refused to do that, so I stayed there and waited to the police, and the police took me in custody, saying that I reached out to the victim. My phone didn't even work, Your Honor, and whatever number they're using, I don't have that number. I have a Google Voice number, which I gave to my probation officer, and that's the only number I have.
Okay, well, let me clear up one misconception.
Go ahead, Your Honor.
At that time, you were not arrested because you had contact with, in violation of my no contact order. You were arrested because I had issued a warrant for your arrest.
Right.
Is that correct?
Yes.
That's why you were arrested. It had nothing to do with the no contact order at that time. You were arrested on my order.
What did I do for you to order that?
You were being rejected from Hill Space.
Oh yeah, I understand that.
Okay,
Yeah,
okay.
I have no problem with that, and that's why I didn't leave there.
Let me read to you what this says, and this is from Hill Space.
Okay.
Jeffrey McDaniel arrived at Hill Space Recovery Housing to complete his intake. Upon arrival, he became upset after learning that his personal belongings from a previous stay had been donated, as outlined in our policy, and then they go on about their policy, 7
Right.
days. Following this, Jeffrey became increasingly agitated and began making threats of physical harm toward both residents and staff.
If I did that, Your Honor, the police, I know what they're saying. They're covering up because I didn't fill out any paperwork for that policy to be in effect, and they knew that. Okay. I promise you, the police came, and the police called my probation officer with the information that I gave them so they could contact her. I never threatened anybody, never did anything. All I said was, how are we going to fix this? Very calmly. I sat down. I even was speaking to the residents. One of the residents let me use their phone charger because my sister has my phone charger. There was no any animosity towards anybody there. Those are people in recovery, and I appreciate people in recovery. I was getting ready to get my peer support before I was locked up. I never would threaten anybody in recovery, nor would I threaten anybody in that regards at all. And if I did, I would have got an aggravated menacing charge because that's what aggravated menacing is. Why did I not get charged with it if I did it? And when I got there at 1:47 from the Uber, and I left they asked me to pee in a cup. I couldn't pee because I used the restroom as soon as I got there. I got in the van with the man named Josh and went to their other facility. There was no time for me to become irate. There was no time for me to even talk. I talked to Shelby like we're talking now. You know, I said, Shelby, is my stuff in storage? She said, I don't know, I don't know, Jeffrey. I said, okay, I'll ask Rico or whoever's over there when I get over there. And I went over there and I asked Rico, and he said, that stuff's been gone. I said, why would you throw my stuff away? And he said, your mom called up here and said you weren't getting out anytime soon to go ahead and donate it. I said, so you let the victim of my crime, allegedly, well, I was found guilty at the time, so it would have been my victim of my crime, call you and just give my property away? And now, granted, if I had pictures, I couldn't get pictures, obviously, because I'm in jail. But all my stuff was in Rubbermaid bins with padlocks on it. If I was that worried about my clothing, you think I would want that clothing donated? And I never signed anything that said 7 days. That was their new policy. I wasn't under that policy. I was under the 30-day policy. And I called within 2 weeks from peer support of the jail. And Rick doesn't work here anymore, but that was the peer support at the time. He called 2 different times and talked to Shelby both, and I talked to Shelby both times on speakerphone. Hillspace is covering for their mistake, which is fine. I don't even care. I just want the court to understand that this is not what should have happened. And I would ask the court to go ahead and throw this whole probation violation out. Keep the no contact order. I have a TPO order that I need to be able to get to Oklahoma video to actually tell another court what I'm telling you now. Because the only reason she wants a TPO is because she messed up. And she fears that I'm gonna be upset with her. It's my mother. She bought most of the stuff anyways. I don't care. But we did have a financial agreement, but I did not reach out to her. We have a financial agreement that she's been my primary caregiver because I have a mental health disorder that doesn't allow me to work. She's been paying my bills. It had no stipulation on whether I was good or bad. She's been paying my bills since my wife and I separated. And if you got my phone, I have plenty of cash apps and plenty of PNC accounts where she's made deposits for multiple things and multiple requests were made. She's been paying my bills since forever, since like 2023, I think, because that's when me and my wife separated. Now she's exiting out of her pretty much a verbal contract that I have text messages from, and now she's saying she wants a TPO and that she's not willing to pay anything of my bills and that she gave all my stuff away. So when I got to Hillspace and Miss Martinez said she was going to give me hygiene and food, which she never gave me, nor did she never give me a copy of the rules and regulations. Yes, I signed them, but I never got a copy of them. And I never got a no contact order from this court. The only 2 contact orders I have is from Corey Avenante, which is no longer there, and one from Magistrate Marcus Mole. That's the only no contact I have. And I didn't contact her. Frankly, I didn't. I contacted my sister and I told her, I said, Samantha, you lied about my stuff being at this place. I'm getting kicked out because of it. And she said, that's what happens when you go to jail. And now I never said anything about cutting my ankle monitor off. That's an F3, which Miss Martinez and I don't know the other man's name. He underlined it, F3 prison if you cut it off. I would never cut your ankle monitor off. That's why I didn't. So I would like to be either terminated and let go because I've already sentenced 5 months of my life on this case, and now I have a TPO in order in Oklahoma. So even if I contact the victim, I'm going to go do a year in Oklahoma plus whatever time you give me. So it would never happen. And if you want to reinstate me, I'd be willing to go to a treatment center in this area. I looked into Woodhaven along as with the coach because I want treatment and I want help. I honestly don't want the ankle monitor on, but if you have to have the ankle monitor for the courts, I don't know what the word I'm trying to look for, just for them to be okay with me getting out and everybody's safety, I'm fine with that. But I promise I didn't purposely or maliciously violate your court order, nor would I ever. I really just want to go to treatment, and I want to get my mental health together, and I don't really have a substance abuse problem, and we went over that. This was really for more mental health. That's why I was going up there, not substance abuse. Just like I didn't use drugs and I passed the drug test that you gave me. I don't use drugs anymore. Out of almost over 2 years, I've only used drugs for 3 weeks. And that's because in the AA book, it says if you feel like you can beat this disease, to go back out and try it. And I did it. And when I figured I couldn't, I went back to recovery. And that's why I was in recovery at Hillspace for 90 days before this event, Your Honor. So I please ask you to please reinstate my probation, give me another shot, let me go to the coach or Woodhaven, and let's move forward.
Okay. Anything else?
That's it.
All right. Sir, do you want this to be marked as an exhibit, or do you want this back?
No, I would like that to be marked as an exhibit.
Do you
Because
have
that,
another copy for yourself?
no, I don't. If I don't even really need, or yes, I would like to have it, because that shows the courts that the initial reason I got charged with this crime.
All right, well, here's what I'm gonna do. I'm gonna have Justin make a copy. Ms.
Okay.
Tranter, do you want a copy too?
No, it's okay, Judge.
All right, just make one copy then. So I'll keep the copy and I'll give you that one back.
Okay, I appreciate it.
All right, have a seat. Is there anything else then, Mr. McDaniel?
No, Your Honor,
right.
just that I would like to go to treatment, that's it.
All right, Ms. Tranter, is there anything else?
No, Your Honor.
Mr. McDaniel, if you will recall, when you were here in front of me back on April the 27th, one of the things that I tried to have a discussion with you about was your demeanor.
Right.
And how aggressive you become. It's not a far stretch for me when I look at the state's exhibits and I read what the email said from Hillspace, that you became agitated and aggressive. I'm not shocked.
I didn't, Your Honor.
Well, I know you're saying you didn't, except I have personally observed and tried to have a conversation with you about your aggressiveness.
They have video cameras there, Your Honor.
Okay, this is the way this is gonna work.
I just want you to know that they have videos there.
Okay, that's not before me. This is the way this is gonna work.
They don't have
I sat here and I listened to you with an open mind. You've had your opportunity. You've indicated that you had nothing else to add or say. So now it's my turn and
Go
my
ahead, Your Honor.
observation. Okay, thank you. The court at the time of your sentencing was torn whether just to send you to prison then or to give you this opportunity where you said you would thrive and have thrived at this Hillspace, where you've now been red flagged and forbidden to return because of your own actions. So the court is going to find that you have violated the terms of your community control. The court is going to find that this is not a technical violation of your community control, and that prison is now necessary to fulfill the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public.
Yep.
Probation would no longer adequately punish you and would demean what happened in this case. Prison is necessary because of your extensive criminal history and your failure to respond to previous community control sanctions. So, I am going to order you to serve 15 months in prison. Do we have a jail time credit?
15 months. It's more than the case it carries.
No, it's 18 months.
And I got 5 months in.
Okay, hang on. We'll get that number
So you're
for you.
maxing me out,
I'll get it for you.
No, I said 15 months. I didn't say 18 months. 18
Oh.
months would have been maxing you.
plus the 137 or 134 jail time
Just let
credit.
me finish my sentence, and then I'll
Go ahead,
ask you if
John.
you have any questions.
Go ahead.
So 134, Judge.
You got 134 days jail time credit,
Right.
15 months in prison. That jail time credit, court finds that you're indigent for the purpose of any fines, costs, or other financial
Thank you, sir.
sanctions. All right, you're also subject to the discretionary post-release control, which means the adult parole authority may supervise you when you are released for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Ms. Tranter, is there anything else?
No, sir.
All right, Mr. McDaniel, best of luck to you,
How
sir.
many good days am I allowed to get?
Oh, I'm sorry, you could receive up to 1 day per month for participating in certain programs sponsored by the Department of Corrections.
Okay.
All right, thank you,
Thank
sir.
you. Sweet. Now let's come to this.
Under Ohio Revised Code Section 2929.15 governing community control violations, Jeffrey McDaniel appeared for a final probation revocation hearing after previously receiving supervision in place of a prison sentence. Conditions of supervision required successful completion of treatment programming and compliance with a court-ordered no-contact restriction involving Sherry Spencer. The state alleged McDaniel violated supervision by failing treatment intake requirements, engaging in threatening behavior toward staff at Heal Space Recovery Housing, and making prohibited electronic contact with the protected party through payment applications and text communications. Prosecutors presented probation testimony, electronic records, and facility documentation in support of revocation. McDaniel denied making threats and argued the dispute originated from donated personal property and ongoing family disagreements. He also disputed intentionally violating the no-contact condition. After reviewing testimony and documentary evidence, the court determined the violations were non-technical under Ohio community control law and found imprisonment necessary to satisfy sentencing principles involving punishment, deterrence, rehabilitation, and public protection. The court revoked community control and imposed a 15-month prison sentence with 134 days jail credit, followed by potential discretionary post-release control supervision.